I'm not seeing it. Did you start the transcription?
If I did, it was inadvertent. Okay,
Oh.
stopped.
Oh, no. Yeah, okay.
Because last time it bogged and froze everything.
Right. I don't see it. I don't see Mr. Knight out there.
Did you click on chat?
Well, I've got the participants. Mr. Knight, are you present there? Because we're not seeing you if you are. Right. Technology is great when it works. Just got a text from him. Are you seeing me trying to log in remotely?
There he is.
There we go. For some reason, it wasn't connecting.
Yeah, I was just responding to the text you sent. I was gonna, you'll see it. I just said, you know, I didn't see anything, but Chris said he saw something very briefly. But obviously now you're in.
Well, it was connecting, and right after I sent the text, I just logged out and tried again. So whatever's happening there is not on this one. So apologies, I'm a minute or two late.
That's okay. Understood. Like I said, Ms. Tavares responded. She had some kind of issue, and then Chris had said he had an issue when he was originally logging in. Anyway, all right. Well, hold on, Mr. Kreitz, you're still muted.
All right, thank you.
There we go.
At this time, I'd like to call the probable cause panel of the Ohio Election Commission to order. Mr. Richter, if you'd conduct the roll call.
Mr. Knight.
Here.
Ms. Tavares.
Here.
Mr. Kreitz.
Here.
Mr. Kreitz, I would recommend you act as chair for this meeting. Any other members that may be present are here just to observe.
All right,
so we have members of the probable cause panel are Ms. Tavares, Mr. Knight, and Mr. Kreitz. Please proceed, Mr. Kreitz.
Very good. All right, sir. The purpose of the meeting of the probable cause panel of the Ohio Election Commission this morning is to address two complaints that are currently pending before the Ohio Elections Commission. Case number 2022G-012, 2022G-013. The complainants in both of those cases, Mary Capella. The respondents are Joe Blystone, Friends of Joe Blystone, and Jane Blystone, Treasurer, Friends of Joe Blystone. At this time, if counsel for the complainant would enter his appearance.
Kurt Hartman on behalf of the complainant.
Thank you, Mr. Hartman. And on behalf of the respondents.
You're mute. Hold on. You're muted still. It says you're muted.
Am I good?
There you go.
For the record, I object to the appearance of Mr. Hartman. He's not made a proper appearance in this case yet, as required by rule. And I am Attorney Josh Brown on behalf of the respondent.
All right. Thank you very much, Mr. Brown. Counsel have entered their appearance with respect to both of these matters. Before we proceed, I think there's a preliminary matter. Is there not? Was there not a motion to continue that was filed earlier, Mr. Richter?
Yes, we had, when I got in the office this morning, there were multiple responses from the respondent. answers, responses, and motions to dismiss filed in both cases. Or I'm sorry, not motion to dismiss, motion to continue in both cases. And so we have those before us. So with those present, we probably should address the motions to continue initially. My recommendation on both of those would be to deny the respective motions, but we can certainly hear from parties and have commission members comment if necessary.
All right. Well, Mr. Brown, it's your motion to continue. Do you want to go ahead and make that argument? And then Mr. Hartman, I'll give you an opportunity to respond, sir. I think you're still muted, Mr.
Yeah,
Brown.
Mr. Brown.
Okay. Thank you, Mr. Kreitz. The motion to continue is based on a few different arguments, and they're laid out in some detail. The first is that the expedited hearing statute itself is unconstitutional. It's deprivation of due process. The respondent was put on notice earlier this month that the hearing in this matter would be May 19th, 2022. I received a notice at 9:57 on Tuesday morning, which would be April 19th, 2022, that the hearing would be held on this matter today, April 21st, 2022 at 9 a.m. That is not an adequate amount of time for any party to prepare for a hearing. And it left me with just a few hours really to prepare anything at all, no less actually prepare documents. So I had no problem with having to work late. I'm a lawyer, that happens. But when I have to work late because of a hearing has been scheduled within a day of my notice, I just think that is a deprivation of due process, because we cannot prepare a case, and I laid out the law for that in my writings. The other issue is that the complainant was given 4 months to prepare for this hearing. The complaint is based on filings that happened, I believe, January 3rd. And so I didn't know this complaint was coming until it was filed. And when it was filed, I thought I had a couple months to prepare. So the complainant has had, since that day, to prepare his complaint, compare his arguments, what I've had in a day, basically. And if you look at the case law, the time you're given, there's not a strict, the courts haven't created a strict amount of time for any particular type of hearing for due process, but it has to be, the amount of time you have has to be adequate for the nature of the case. I think this is a complicated case with a lot of moving pieces. I think we have 5 different counts that we're addressing here. So I believe one day is just a complete and total injustice to my client and myself. The second piece of law I'm referring to is there's quite a bit of case law that says that administrative hearings in Ohio have to be fair. And I think that giving me 1 day to prepare and the complainant 4 months to prepare is patently unfair. And so we don't need a lot of time. I think that if I just had till Monday next week, that would be sufficient. So I would only ask for a continuance of a few days. Just give me the weekend so that I can polish up my filings and you know, be a little bit more prepared. We do want to deal with this quickly, and that's why we actually didn't object to this. We actually said in writing we don't object to an expedited hearing, but at the time I didn't realize it was 2 days. And I talked to Mr. Hartman on the phone, and he mentioned, yeah, it's 2 days. So I do want to do it quickly. I just think that if I just had, you know, if we did it Monday, I would have 3 more days, and I think that would be sufficient. Thank you, commissioners.
No, thank you very much. Mr. Hartman?
Thank you, Mr. Chairman. With all due respect to counsel, I believe counsel's arguments misunderstands the nature and process by which today's hearing is being conducted. It is not an adjudication on the merits today. This is simply a panel to review the complaint and determine whether there is probable cause of a violation such that a full evidentiary hearing will be held within 10 days pursuant to statute. There's not going to be an adjudication, and so therefore there is no issue of life, liberty, or property being adjudicated by the panel today. I think that's first and foremost. Secondly, the General Assembly has mandated this timeline. It actually provides that notice shall attempt to be given, but if it's not, it recognized the nature of what today's hearing is and is not. Finally, I think just in terms of having notice of the complaint itself, I think Ms. Brown kind of implicitly acknowledged he was aware of this complaint earlier this month. It was filed on April 7th. I know there was an email from Mr. Richter to both Mr. Brown and myself the following day. So council's had an opportunity to be aware of the allegations, et cetera. And finally, this really concerns with information that should have been reported and was not reported in January. They should be in a position to defend it in a timely and prompt manner. But fundamentally, I'll go back to the original argument. This is simply a probable cause hearing. It is not an adjudication on the merits. It is not a full evidentiary hearing. Therefore, due process is minimal to the extent it even applies. Thank you, Mr. Chairman.
Thank you, Mr. Hartman. Response, Mr. Brown?
Yes, Chairman, thank you. First of all, I do understand the statute, so I don't appreciate that comment, but Mr. Hartman stressing that's not an adjudication on the merits. There's an adjudication as to probable cause, and so that is an adjudication. The difference is the standard, not the question of whether it's an adjudication or not. It's a standard of probable cause. In other cases, I have seen complainants get their probable cause ruling from this very body and then go online, go to the newspapers, go to other courts and stress that they have achieved probable cause in their case. It is, and Mr. Hartman mentioned, it's not a life, liberty, or property. The law considers an interest of the respondent a property interest, and hit the reputation of the respondent and the nature of communications that are disseminating throughout our society is an interest that he has. And if he's unfairly determined to have violated a statute to the standard of probable, which means he probably did it, that is the standard we're dealing with. Did he probably do it? That affects his interests. It also causes him to have to invest more into this case and have to defend a case where the probable cause was unfairly determined. The General Assembly did mandate this, but it's patently unconstitutional. And I was aware of the complaint earlier this month, but I'd love to see how Mr. Hartman would respond if I told him our hearing date is May 19th, and then a few days later say, no, I want to do it in one day. I think no lawyer in this country is okay with that. Thank you, Commissioner.
Thank you, Mr. Brown. Mr. Richter, what are your thoughts on the motion to continue, sir? Mr. Richter?
There.
I think you're on mute, Phil.
I don't mute anymore, I don't think.
No, I can hear you. Go ahead.
Yeah,
You're on mute.
I was for a while. That's why I wasn't responding, is I was ignoring you. It just kept clicking on the microphone. It wasn't unmuted. Now I'm unmuted. Well, first off, I said before, and I'll repeat it now, I would recommend the commission deny a motion to continue. I pulled both arguments played before the commission. Realize that this commission, for almost 20 years, regularly conducted probable cause panels, and the commission's actions in those probable cause panels was regularly challenged in court after a final decision was made, and no court system ever declared the commission's probable cause process a probable cause panel meeting within 3 days, essentially. And then having full hearing was never challenged. Well, challenged, and it was never upheld in court that it was proper infraction or imposition of due process. We do our best to get notice of the parties as we did here. Obviously, both parties were sufficiently notified that we were going forward today. We're going forward. And so considering not only the commission's history, but where we are, and we have both parties present, I would recommend to the commission that the motion to dismiss really cases be dismissed. I just wanted to make Mr. that our argument is, as it relates to cases, even though we're not considering both cases, the final determination of both cases, for argument's sake, we can argue both cases together. Is that correct,
That's correct.
Mr. Chair? Okay.
Yes.
Yeah. So my recommendation would be to deny the motions to let go forward with the probable cause panel. Probable cause decides and move from there.
Mr. Richter, as a matter of, well, before I do that, Ms. Tavares, Mr. Knight, do you have comments?
Not at this point.
I don't have any at this point. Thank you.
Thank you. So based upon your recommendation, Mr. Richter, we're going to go ahead and deny the motion to continue, and we're going to go ahead and proceed this morning. I should note once again that counsel have entered their appearance. As a matter of procedure, what we're going to do, since it's Mr. Hartman's complaint, Mr. Hartman, I'm going to give you the opportunity to proceed first to make your arguments. Then Mr. Brown, I'm going to give you an opportunity to respond to his arguments. And then, of course, we'll come back and we'll allow you to have the last bite of the apple, Mr. Hartman, an opportunity to reply. At that point in time, we'll cut off we'll allow the commission to go ahead and ask any questions of the attorneys that they might have. Upon conclusion of that, we'll cut off the argument stage of it, and then the commission will proceed to have a discussion amongst itself and decide what, if any, action it decides to take. So any objections to that procedure?
Your Honor, I object to Mr. Hartman's being allowed to speak on behalf of the complainant in this case under OAC 3517-1-02A1C. He has not made a proper appearance in this case because his name does not appear on the complaints, either of them. Thank you.
Mr. Hartman?
I've entered my appearance here today.
Thank you very much. Going to overrule your motion, Mr. Brown. Thank you very much. You preserved it for the record. With that, Mr. Hartman, I'm going to allow you to go ahead and proceed. I would ask, Mr. Hartman, I'd ask that both counsel go ahead and consolidate their arguments as to both of the complaints in this case. So with that, go ahead, sir.
No problem, Mr. Chairman. If I may get a point of clarification from the chairman in terms of procedure today, looking at the rules of the commission, I'm specifically referring to Rule 3517-1-10, dealing with expedited hearings. Division D declares that, quote, at the probable cause panel meeting, the panel shall not hear arguments, receive evidence, or take testimony unless there's a stipulation and the panel agrees. So if I can get clarification, are we limiting it to argument? Or are you looking to open it up for more evidence, notwithstanding the rule, or how are we doing with respect to that?
Mr. Kravitz, you're muted.
My apologies, gentlemen, ladies.
No.
My understanding, Mr. Richter, correct me, is that we are going to go ahead and entertain just arguments this morning on both of the.
That's correct.
That's
That's correct. We have all the material. All the materials have been provided. I've also circulated all of that.
We just want to hear arguments as it relates to both.
Arguments as it relates to both.
Okay.
Were you able to understand that, Mr. Hartman? I'm sorry.
I didn't understand it all. I think I got the gist of it, though.
All right, Mr. Richter, again, I don't know whether it's feedback or whatever it is, but you're very difficult to understand. So could you please slow down and let's try it one more time, just so that we can make the record, sir.
Great. I just get a note in the middle of my computer. There's a bad network quality here, so I apologize, but that's
I
the
wasn't
state of
suggesting,
Ohio.
I wasn't suggesting
No,
for
no,
a
no.
moment it was you.
No, I understand, but you know, it is what it is. We're, I'll repeat, I'll try and do it a little bit more, let's say slowly. We have the complaints. We have all the responses that were submitted. Those were all circulated to all of you for your consideration and review. That being the case, we don't need a total repeat of all of those materials for your edification, for your respective edifications. What we want is only argument on the respective complaint and the responses, complaints and responses, so that the commission has an ability to determine anything further that may be beneficial to them in order to make its decision as to whether there is probable cause present or not. So that's where we stand. It's just essentially argument at this point, and we'll hear from respective counsel, and then the commission can ask questions and be prepared to move forward from there.
Thank you very much, Mr. Richter. Mr. Hartman?
Thank you, Mr. Chairman.
Oh.
As I
And,
indicated,
I'm not, hold on, sorry. Here Mr. Brown is here present, and right as I was finishing, he said he wanted to make a motion. I'm not sure what it is, but Mr. Brown, you know, you've been muted, so you're going to need to, Mr. Hughes, I have to unmute you. I'm not sure what you want to do, but go forward.
On this issue of whether we're going to take testimony and evidence, I would like to make a motion, but I'll let the chairman open the floor if he wants to hear from Mr. Hartman first. That's okay with me, but I just want to get my motion in.
Okay, what is your motion, or do you anticipate making, or you're going to make?
I want to make a motion for the commission to take evidence and hear testimony. I have two witnesses here that can specifically address many of the counts that are going to be discussed here today. And we believe we can make a full case as it relates to this probable cause, which is a very important interest. You know, when I used to work at the prosecutor's office in Detroit, and we did nothing but probable cause and probable cause hearings. And we were always able to put up witnesses. We consider this probable cause hearing to be very important for us, and especially given the timing. And so we would like the opportunity to make our full case and our full arguments here today. Thank you. So I move for parties to be able to submit evidence through testimony.
Mr. Hartman, you have a
I
response to that?
make sure I'm unmuted. I would object to that. First time I've heard this, Mr. Brown could have told me he was plans of yesterday. I could have prepared the exhibits more fully. And again, he's trying to short circuit the process. This is simply a probable cause meeting. Actually, the rule characterizes that as a probable cause panel meeting to determine probable cause. The time for the full adjudication, I mean, it's not designed to be here for hours on end. You know, cross-examining witnesses, offering rebuttal evidence, etc. And therefore, I would object to it, and it's not consistent with the rule, which requires a stipulation to receive evidence and the panel's agreement thereof.
Mr. Richter?
Historically, the commission has not taken evidence in a probable cause panel. We've just heard arguments from counsel. If a respondent was present, we may hear from them in terms of what their response is. But since Mr. Brown and Mr. Hartman are both here representing, our history in probable cause panel reviews has been to take arguments from counsel and then make a determination. That's what my recommendation would be for the commission to do. But if the commission would decide to go in another way, that's certainly within their purview. Alternatively, considering it's only a 3-member panel, a final resolution cannot be made in terms of finding a violation after hearing evidence. It has to go to the full commission in order to have at least 4 members vote on any particular item. So this isn't a situation where let's say that even with Mr. Brown's presentation, the commission wants to find a violation. There's not a sufficient number of commission members present in order to find a violation in a case. Not assuming there's a violation, but you know, that's kind of where we are. That's why this is a preliminary type of matter, and and I would certainly only recommend taking argument.
Mr. Richter, with respect to the comment that stipulation is required to entertain testimony, is that correct?
Yeah, that's what the rule says. I don't think in all the years we ever did probable cause panels, we ever had a stipulation from parties to that. But it does take agreement of the commission
to take anything other than
argument.
and again,
Historically, we've only taken argument.
Mr. Hartman, I'm assuming you're not prepared this morning to stipulate to testimony?
Not full testimony. I mean, you know, I would have witnesses where my opportunity to call witnesses today is not being respected if we did go down that path. So no, I'm not prepared to fully present the case. I was here for a probable cause hearing.
So you're prepared to go ahead and make oral argument?
That is correct.
All right, thank you. All right, we're going to overrule your motion, Mr. Brown. Thank you very much. With that, Mr. Hartman, you have the burden. Go ahead, sir.
Thank you. And may it please the commission, Mr. Chairman. As I did indicate earlier, and have emphasized, we are here at a probable cause hearing. And I would lay the foundation for the arguments and for the panel's consideration today. What is probable cause? It's not beyond a reasonable doubt. It's not even a preponderance of the evidence. It is a very low evidentiary standard. And I've tendered to the commission yesterday a brief memo, one-page memo on what is probable cause. And when you keep focused on that issue, it describes it as a flexible, common sense standard dealing with probabilities, not certainties. It only requires the existence of circumstances that warrant suspicion. It does not require a prima facie showing of wrongdoing. It's really just a probability that wrongdoing may exist. And I think clearly by the complaints, which are predominantly based upon the campaign finance filings that occurred for the 2021 annual report, probable cause does exist, which would warrant moving this forward with a full evidentiary hearing so that the matter could be determined by the full commission. Complaint number 012 deals predominantly with contributions. And it got to back up a little bit to the earlier case that's also pending before the commission in case 2021 G22, Sarah Chambers versus Joseph Blystone, which the full commission found sufficient grounds or probable cause to proceed forward with on a hearing there. It's kind of related to those complaints, but interestingly, the commission had its meeting on probable cause back in December, well before the filing of the 2020 annual report. So clearly the Blystone campaign knew or was aware of the various issues and the various requirements under the campaign finance laws as to what they could and could not do and what they had to report or could not avoid reporting. And similar to that earlier report, we are getting massive numbers of location entries or events, a pumpkin festival or et cetera, with just a single line entry of dollar amounts, $3,000, $2,000, et cetera, all adding up to $95,000, 28% of the contributions received by the Blystone campaign during the last 6 months of 2021. And that clearly, and based upon that and the complaints from the Chambers complaint, which we incorporate by reference, there's the indication that we're not getting the disclosure of those who contributed. And it's interestingly, I actually had a brief opportunity this morning to review the response that was filed there on behalf of the Blystone campaign. And essentially, I think there is an admission within there that they are not tracking any of these contributions. That in November, they started circulating things, but we don't have to report anything under $25, don't have to track anything under $25, and therefore we're not. That is required to track whether or not you report it individually or not, you have to track it. Secondly, I would note that the campaign finance reports don't make any indication how many people contributed for each line entry. Most campaign finance reports, if they want to do a one-line entry on contributions under $25, say, 48 contributions, all under $25 total, whatever the number total contributions are. Here, we don't even have any indication. There's no indication of how many people contributed, whether they all were under $25, whether all the cash contributions were under $100. And so I think there is at least some indication and a probability that wrongdoing does exist when you receive the 95,000 plus or minus dollars, 28% of your whole contributions, and you don't report any of it. In terms of the expenditures, again, I think the reports indicate certain questionable expenditures. There are massive numbers of bulk fuel purchases. No indication, clearly not being reimbursed at the IRS rate, not being tracked in terms of travel to and from an event, so many miles, reimbursement of mileage. Reimbursement of mileage, paying for fuel is acceptable, but there has to be the necessary, ordinary, and reasonable campaign expenditures. And there are some, I believe, some opinions issued previously by the commission indicating that you need to be monitoring starts where I started, where I ended, how much time, what date equals a dollar amount, and then a reimbursement is made. Here you're looking at $300-400 a day fuel purchases. And so that clearly rises or creates at least a probability of the conversion of campaign funds for personal use. Similarly, you got campaign reports of the purchase of at clothing stores, which again are would not be a necessary, ordinary, and reasonable expenditure of campaign funds for the purposes of advancing the campaign, but can also be used for the personal conversion. So at this stage, I would, I think the complaints adequately rise to the level of probable cause. That is a probability of wrongdoing, not the definition, not a definitive, not even a prima facie demonstration, but just a probability of wrongdoing. It warrants suspicions, therefore probable cause does exist. We should proceed to the full evidentiary hearing before the commission and allow all the evidence to be presented. Thank you, Mr. Chairman.
Thank you, Mr. Hartman. Mr. Brown?
Yeah, thank you.
Thank you.
Thank you. Okay, so I've had to construct, the whole case here within a day. So I would just ask if you cut me some slack on some pauses here, just so I can keep gathering my thoughts as I go along.
Take
Normally,
whatever
I would
time
be
you need,
first.
Mr. Brown. Take whatever time you need.
Mr. Kreitz is a very experienced lawyer, and he knows sometimes we take weeks preparing for these things normally. So just forgive me for the lack of fluency here at times. The first thing I want to mention is that we only addressed one of my bases for motion to dismiss. Mr. Chairman, would you like to entertain that at the end of arguments, or would you like to go ahead and just deal with that now? Or I think putting it at the end would probably make sense, because I'd like to respond to Mr. Hartman's argument sooner rather than later.
I would prefer, and you have to handle your argument the way you want to handle it, but I would prefer that we kind of consolidate all of our arguments. Mr. Hartman, as Brittany went forward, you go ahead and address all the issues that you have and get them before the commission, and then we'll come back and we'll let Mr. Hartman respond to that. So I would prefer to do it that way. If that in any way impacts, prejudices your arguments, then of course we'll break it out the way you want to do it, Mr. Brown.
Okay, thank you, Mr. Kreitz. I'll just address the motion to dismiss first. The complainant's affidavit is insufficient. The affidavit says, and I'm going to read the entirety of the affidavit here. Complainant Mary Capella, having been fully cautioned and sworn, states that the facts in the foregoing complaint are based on personal knowledge supported by the exhibits and attached here too and are true and accurate. That's the entirety of the affidavit. That is not a proper affidavit, and I know because I've made this mistake myself before, and I've had my affidavits thrown out on that same exact basis. The affidavit has to state facts. She can't just swear to everything that's in the complaint, especially considering the fact that an affidavit must be on personal knowledge, and under the Ohio Elections Commission's rules, that affidavit also has to state, and I'm looking for the language here, the specific source or basis of the personal knowledge. The fact that that affidavit does not state the basis or source of that personal knowledge makes this complaint unacceptable and therefore must be dismissed. Also, if you do accept this affidavit, then she's swearing to the truth on personal knowledge of legal arguments, such as proper citations to statutes and the meaning of those statutes. That is not something that a person can affirm as a fact of personal knowledge. All right, so just want to get that on the record, and then I'd like to now respond to the arguments that Mr. Hartman laid out.
Very good, sir.
So I'm
Go
going
ahead.
to start. I'm going to start with case number 2022 G012. It would be helpful if commissioners had that complaint in front of them and my response to that complaint in front of them. First thing I need to do is get my copy of it out. All right, so the 012 complaint basically lays out two violations, and both of them are essentially for the same thing, which is the argument that the campaign took donations of less than $25 in cash and did not report the information that is listed as information to be taken under 351710B4. I believe that. Yeah, that's it. Okay, so in my response, the first thing we did was we stipulate that the campaign did not take that information before November of 2021. But our mitigation of that is that the campaign operated under a good faith, reasonable interpretation of 351710B4E. In the complainant's complaint, he ignores Section E, which I think is a disservice to this body, because I think that our duties, as Justice Fisher recently laid out in an opinion, are to lay out the entirety of the law and need the arguments for and against your case. So the way the section works is 351710B4 lays out all these different things that you have to report. Section E literally says except. The word except is in the statute. So Section E says that you have to report a separately itemized account of contributions and expenditures. That just means you have to file two reports, one's for expenditures, one's for contributions, except, and I even included the definition of the word except in my filing. Under an exception means it doesn't, it's somewhat, I'm reading this definition, someone or something that is not included in a role, group, or list, or that does not behave in the expected way. Section E is explicitly an exception. And it says, accept a receipt of a contribution from a person in the sum of $25 or less at one social or fundraising activity. Thus, the law does not require the campaign to take the information from that 3517B4 because there's an explicit exception laid out. Now, where the complaint might take you is to OAC 111 semicolon or colon 2-4-13A. Now, that would appear to contradict section E, the exception. And I'll read it to you. Account shall include the name and street address of the contributor, date the contribution was received, the form in which the contribution was received, and the amount of the contribution. That section clearly would contradict the complainant's interpretation of 3517-10B4. I also laid out in my complaint that the Ohio Elections Commission does not have the authority to promulgate a rule that contradicts the Ohio Revised Code. So if that rule is interpreted to contradict section E, then the rule is the thing that gives way. The revised code section is what is applicable. Thus, to the extent the commission may interpret that rule to conflict with section E, the commission would be acting illegally. Okay, and I would urge the commission, I know that I had one day to prepare that filing. I sent it to the Elections Commission about 11 o'clock last night, and it's not up to my standards and the quality of work that I do. It's the best I could do in one day, and so I would urge you to read it, because I do think at least everything's in there. At least, if I'd had the time to prepare it, that would have been the foundation of what I would have filed at least. Okay. Now I would like the commission to move on to complaint 013, the next complaint. And if you don't mind, we'll take a drink real quick. All right, so here we have a response to, we have responded to every violation. The complaint frames it as violation number 1, number 2, number 3, number 4. So I'll start with violation number 1. The allegation is that the campaign failed to file receipts and or other documentation supporting the expenditures for 2021 annual report. The respondent is going to stipulate that we did not file receipts and documentation supporting the 21 annual report. However, this mistake was made in good faith. The respondent was unaware they need to file these documents. I know the other side will probably take issue with that, but what was basically happening was, and that's one of the reasons I wanted to have my witnesses testify, the people that were preparing are not professional, and this is the first time they had done it, and they were calling the Secretary of State and some of his staff, and I guess along the way it just never came to their attention. However, the Secretary of State wrote us a letter. Now that is attached as Exhibit A to both of my responses. I know that in the Google Drive that I sent, I should have sent 4 documents. I sent 6. So there's 2 documents there that say answer. Those you can dispense with, and when I get a chance, I'm going to go ahead and delete them from the Google file, but or the Google Drive. But the 2 that say response have, and the reason those 2 answers are not the proper documents because they don't have the exhibits attached. So the ones that say response, and it says response to 012, and the other one says response to 013, they have the exhibits. So Exhibit A is the letter that the Secretary of State wrote to the respondent, and it lays out, I believe, 27 paragraphs where it discusses things that they would like the respondent, in this case, the campaign, to respond to them. We talked to them on the phone as soon as we got that letter, and we asked them to give us till April 15th. And on April 15th, we did send a very, very detailed response. And that response is attached to those two responses that you have in the Google Drive as Exhibit B. So you have the Secretary's letter as Exhibit A, and you have our response as Exhibit B. Okay, so as it pertains to violation 1, the Secretary of State addressed that with us in paragraph 26, and we responded so that would be Exhibit A, paragraph 26, and then our campaign addressed this response in Exhibit B, page 46. To date, we have not had time to upload those receipts and documents, but they will be entered, and we went ahead and picked a date. We said Monday, April 25th. So we have the documents basically organized and just sitting there. They need to be scanned, and we will have that violation and that issue Secretary of State brought to our attention fully corrected by Monday. Today's Thursday, for the record, April 21st. By Monday, April 25th, we'll have those. We'll have that issue remedied. Okay. So now I'd like to move on to violation number 2. Violation 2 says the campaign knowingly concealed information required to be reported. And the thing that was required to be reported is the object or purpose for which expenditures were made. The complaint says, and thus respondent failed to file a full, true, and itemized campaign finance report. I'm paraphrasing, by the way. Okay, so this is another matter that was brought to our attention by Secretary of State in his letter. So that would be Exhibit A, paragraph 22. We believe the respondent's reply will satisfy the commission that this matter was adequately addressed in respondent's report to the Secretary, which is the April 15th Exhibit B response. And our response is on page 39. So for your reference, the Secretary addressed the matter in paragraph 22, Exhibit A of his letter, and we responded on page 39, Exhibit B of our response. And so rather than go through the details, basically what happened here was the treasurer, being inexperienced, just didn't really comprehend the level of detail that was required. And those are relatively easy amendments. We're just going to explain it, but we have that information. We absolutely believe that that's going to be remedied and will not be a problem. And by the way, the campaign has brought in professional staff now to help with these amendments and help with these issues. So we feel confident that the people we're working with will make sure that that this is all remedied. And I'm not saying it shouldn't have been done right in the beginning. There's a lot of internet trolls out there that take everything I say and everything I write and twist it. Campaign's not refusing responsibility, not saying they shouldn't have done it right the first time. What we are discussing now is mitigating factors. All right, the violation number 3. Campaign utilized or provided campaign funds to benefit respondent Joseph K. Blystone personally. Okay, now that one we are adamantly denying. And there's quite a bit of offense taken when you look at something like an Amazon purchase, for example, and say, oh, he must have used the card to buy something for himself. That is not an assumption. That is just making things up, basically. So we really don't appreciate this particular violation. So I'm just going to go through them. There are 4 things that the complaint pointed out, and then I believe he added one in his remarks today. So we'll address them all. The first is quote, multiple purchases from Amazon in a total amount $649.78. This matter is addressed in detail in Exhibit B, our response to Secretary of State, page 39. And each and every single one of those Amazon purchases were for the advancement of the campaign. And Mr. Blystone never benefited personally from that or any other campaign money. Okay, so let's go on to his second one, which is B in the complaint. I'm quoting here, various purchases at Blystone Farm / Blystone Restaurant, family business of Joseph K. Blystone. Okay, so this matter was also addressed in the respondent's campaign report from April 15th, Exhibit B. It's on page 39. Basically what happened here was there were campaign meetings at the restaurant on a regular basis, and campaign money was used to buy lunch for them or something of that nature, which is a very, very typical. I've been on maybe 20 campaigns in my life, including statewide campaigns. I used to work for the ORP. Since I'm not being able to elicit testimony, I'll tell you myself from my own experience that it is not unusual for the campaign to buy lunch for volunteers at a meeting. That is advancement of the campaign. And the commission, I haven't had time. This is one of those things that I had more time, I could have given you the reference. And I wish I had remembered to do this, but I actually have it in my files here. The commission has issued advisory opinions that you can actually use campaign money to buy something from the candidate's business, as long as you don't pay more than fair value and you're not doing more than, as long as you're doing something for the campaign and you're not paying more than fair value. And I can follow up with the commission's advisory opinion on that. All right, I'd like to go to I'd like to go to the third specific allegation in that violation. I believe that's violation 3. Yeah. So C, quote, multiple purchases at Rod's Western Palace, which advertises itself, he gives the website, as your source for everything Western, from Western apparel to, and tack. You don't know what tack is, that's stuff you need for horses. So your source for everything Western, from Western apparel and tack to unique Western gifts and home decor, unquote. Total amount $350.50. We deny any wrongdoing here. Campaign purchased cowboy hats, which if you have driven anywhere in Ohio, you know that the cowboy hat is an icon of the Blystone campaign. Very well-known icon of the Blystone campaign. In fact, I see him on Zoom here wearing his cowboy hat as we speak. And so Joe would sign the cowboy hat and use it at campaign events. Sometimes it would be in exchange for a donation, or it would be auctioned, or it would be a gift to a volunteer who's done a great job. Things like that. So that is detailed in Exhibit B, which is our April 15th response to Secretary of State, page 39. Okay, so then I want to go to D, which is the last in violation 3, the last specific allegation. Somebody's talking, so I just want to. Can you guys step out, please? Thanks. Sorry about that. Okay, I'm on D here. I'm going to quote, a purchase at Silver Spur Western Store, which advertises itself and then the website as the leader in Ohio for a complete line of Western wear offerings. We deny any wrongdoing on this one. Same thing, cowboy hats and a dress that were used at campaign events. Mr. Blyson doesn't have possession of any of those cowboy hats. You know, they were all used in campaign events as an icon, as a prop, and as a motivational tool, so forth, at campaign events. Just in case you're not aware of the nature of this campaign, Mr. Blystone is running a very unique campaign. And I think it's a great thing, by the way. He's built this campaign on very small donations. He's built on, by traveling across the state, city to city, county to county. And the campaign is almost exclusively built on donations from individual Ohioans. This contrasts his campaign from most other campaigns. And I'm not trying to work this in as an election thing, but it just happens to be a relevant fact here that he doesn't take, at least what I saw, you won't see long items of campaign contributions from any kind of lobbyists or these associations that give all these companies that give all these donations. The way he's raised his money is he shows up at a small town and maybe goes up on a stage, maybe speaks from the bus, and he just speaks what he has to say, and people choose to give money or they choose not to. They've done things like they set up a table a lot so they can get out their literature and get out their yard signs. They actually don't give out yard signs. They exchange them for $5, which amazed me when I found out how many of these yard signs are across the state, that those weren't just given out to people. And so the nature of that campaign is not necessarily accommodated perfectly in the code. And I think that, this idea of taking a cowboy hat, signing it, and using it as a prop and motivating people is something to be encouraged in this state. It doesn't violate any rules, and it shouldn't. And so that brings me to, now that I've explained that, this bulk fuel purchases, which is something Mr. Hartman added to his written complaint. At least I didn't see it in the written complaint, so I apologize if it was in there. I just don't, personally, I don't remember seeing it in there. So the campaign has a Winnebago, an RV. That Winnebago is rented exclusively for the use of the campaign. So I do, I'll tell you how this went. When I spoke to the campaign, we talked about how fuel ought to be taken care, or how that ought to be addressed. And the keeping track of the mileage and the start and stop, it's not required by anything, but I would agree that that is a best practice. However, it's actually, it really is not important in this case because the RV is used exclusively for the campaign. And thus, there is no reason to keep track of the mileage and the start and stops, because if you're strict about only using the bus or the RV for campaign-related activities, then you can ensure that no fuel that went into the bus was used for anything but campaign use. Thus, the accusation unnecessary, I think, that he's converting campaign money to personal use, speculative at best, and just flat out wrong. Now that I've made these facts clear, and the witnesses I brought with me today, we're going to testify to the details of that and how we've handled it. All right, so I think I have gone through everything. Let me just make sure I have. So the last thing I want to address is this issue of probable cause. I think it's telling that the complainant very much wants you to take this lightly. And I think that you would not only be doing this state a service and all the people that are interested in this governor's race, And the parties in this case, you'd be doing them all a disservice by not taking this lightly, or you would be doing them a disservice by taking this lightly. But beyond that, I mean, you'd be doing the legal process a disservice by taking this lightly. This probable cause label is one that I anticipate will be used as a campaign tool. I anticipate commercials being run, possibly, certainly online mob, online troll type comments. In another case, the probable cause has been brought up, but we don't have to prove anything now because we have probable cause established. It is a big deal, and it should be taken as a big deal. And so I really believe that General Assembly has made a big mistake in expediting it this in the 2-day time frame. I think the commission made a mistake in changing the scheduled date, but given all of that, we've been able to explain or mitigate almost everything here. So probable cause is not a low evidentiary standard. And when I did probable cause hearings for the prosecutor's office, the judges frequently denied us. Probable cause requires enough evidence to say that it's more likely than not that somebody did something. So I think that if we're being fair, what I would like you to do is go through each of these violations one by one. And where we stipulated, we kind of have to just live with what you want to do. I think we can probably come up with a good settlement on that. The things we've settled, we have stipulated to are things that were done in good faith and things that are fixable. There's nothing here that's not fixable. But on the ones where we deny, and we've laid that out in writing for you, we strenuously urge you to take the items and the information I've given you today and not find probable cause on those. Thank you, Mr. Chairman.
Thank you, Mr. Brown. Mr. Hartman?
Thank you, Mr. Chairman. I gotta say, I repeatedly through Mr. Brown's arguments, I kept hearing, oh, you know, first time campaign, we're not used to this, we haven't done this and that. This isn't a school board race where somebody raised $500 and there were issues in terms of their campaign finance report. This is a person running to be the chief executive officer of the state of Ohio, has raised over and reported over $500,000 in contributions. That's indicated on this, I think, Exhibit A to the 012 complaint. We raised over $500,000. And the excuse is, well, we haven't done this, we're not sophisticated, it's not amateur hour. Yet that seems to be the entire defense. To address, you know, and final thing, one thing Mr. Brown said at the end was about this being a disservice to the people of Ohio. What is a disservice to the people of Ohio? It's not complying with the law. Not providing full and complete disclosure of campaign finance regulations. I mean, we all know campaign finance rules came out of Watergate. They're post-Watergate enactments, both at the federal and state level. And the issue is supposed to be to provide information to the voters of the state of Ohio about the source of funding, how things are being spent. And the Blystone campaign has done none of this. We get told the General Assembly made a mistake. General Assembly didn't make a mistake. They pronounced the law. The mistake is on the Blystone campaign, and the evidence before this panel clearly establishes at least probable cause to proceed to a full evidentiary hearing thereon. To address the kind of the arguments that were made. I don't want to belabor some of them, but I think some of them are important. In terms of the personal knowledge complaint, firstly, it's legal conclusions aren't personal knowledge. Legal conclusions are that any affidavit does not consider that. But clearly, the complaints indicate where the source of the information was, a review of the filings from the Secretary of State's website, and that. So there's clearly a self-evident personal knowledge, and when personal knowledge is self-evident in a complaint, you don't, or an affidavit, you do not have to ferret out that basis. Mr. Brown started talking about the mitigation of their efforts. Mitigation is not an issue here today. Mitigation may be an issue once a violation is found by the full commission, but it's not here today. The only argument he really makes with respect to the contribution complaint is that the Ohio Administrative Code is unconstitutional. That he said that the commission didn't have the authority to adopt the rule. If you look at his response, I'm looking at page 3 of his response. He says, thus the gathering of the information listed in 3517.10b4 is not required under the circumstances of Section 4E because of that exception of not having to individually report contributions under 25. He then goes on and says the total donations taken at an event may be reported in the aggregate, and the campaign is not required to take down the information required by the rest of 3510b4. And since he made reference to it, I would say look at the response to the Secretary of State that they recently filed. It's Exhibit B. It's on page 2 of that, page 30 of the PDF document. And if you go to that, it's very telling. They basically declare that all of these single line entries, and this is dealing with their semi-annual from 2021, but it appears it has continued over into the annual report that's at issue here. All these single line entries, they declare as anonymous contributions totaling $1,000, $3,000. But if you listen to what Mr. Brown said, it wasn't just a coincidental anonymous contributions occurring. What you have here and what he implicitly said was that the campaign designed, organized, and implemented a structure to take anonymous contributions, to deliberately avoid getting the information of each contributor. That is a violation. It's not that a donation showed up in the mail, somebody sent a $50 bill in the mail, and that was the extent of it. It was deliberately designed by the campaign to take $95,000 anonymously. I would refer to the Administrative Code 111-2-1-05, which talks about best efforts. And there, the rule provides that when the treasurer of a candidate's campaign committee shows that best efforts have been used to obtain and maintain and submit the information required by Chapter 3517 of the Revised Code, any report of such committee or fund shall be considered in compliance with such chapter. That is proper. Best efforts to obtain information relative to all these anonymous, unattributed campaign contributions. But when you design a scheme to take, receive, and accept anonymous donations as anonymous donations, that is not best efforts. I think there's at least a sufficient question for it to go before the full commission there. Yeah, in terms of the expenditures, Ms. Brown indicated, well, the receipts were not filed. We didn't know that. They most certainly knew it. You look at Exhibit B to that complaint, the 13 complaint, where I did a public records request to the Secretary of State for the receipts. They produced the receipts from the 2021 semi-annual report that was filed in July of 2021. They filed those with the Secretary of State's office. They knew they needed to file them. But when it came time for filing the receipts for the annual report in January, they didn't file them. At least a sufficient indication of knowledge that they needed to file them and didn't file them. Final thing, I don't want to belabor the commission. I appreciate its time this morning. You know, a lot of argument from Mr. Brown on all this, but as is well established, arguments of counsel is not evidence. Correction, arguments of counsel are not evidence. And therefore, what we have here is simply posturing self-serving declarations. For the probable cause determination, and I've cited to the court, I've cited to the commission, the legal standard from court cases as to what the standard is for probable cause. We have most certainly met it. It needs to proceed forward for that full evidentiary hearing sooner rather than later, so the facts can get out to the people of the state of Ohio, and this amateur hour needs to stop. Thank you, Mr. Chairman.
Thank you very much, Mr. Hartman. At this time, I'm going to ask whether Commissioner Tavares or Commissioner Knight have any questions of counsel.
I just have one question, Mr. Chairman.
Go ahead, ma'am.
The question goes to the attorney for Mr. Blystone. Did the campaign at any of these events attempt to do a registration or a sign in at the event to show who the individuals were that were at that event that contributed less than $25 each?
Mr. Brown.
Thank you. Thank you, Commissioner Tavares. There was no deliberate design to implement this. It was based on a good faith effort, or I'm sorry, it was based on a good faith interpretation of the statute. And so no sort of sign-in list. And if you're familiar with these events, I'm not sure. A lot of this is like setting up at a county fair or setting up near another event, setting up at a park. I don't know if it's practical to have, some sort of a sign-in list at some of these situations, but the answer to your question is that they did not do that.
And I guess just to follow up, Mr. Chairman, I'm very familiar with campaigns and
Sure.
Having been a candidate myself, so I know what the law is, but I also know that as a candidate, you want to thank your contributors. And one way to do that is to have a registration list, even at a pop-up event like a county fair. If somebody puts money into a basket or makes a checkout, you would have that as documentation so that you could thank properly those who have contributed. And so that's why I asked the question, were there any of those events where you had contributions less than $25, where lots of money was collected, whether it was a little bit or a lot, that you had some evidence that there was an attempt to gather information to comply with the law, but also to even thank the contributors on behalf of the campaign?
Yeah, to answer your question, Commissioner, we never said that the commission didn't have the authority to promulgate that administrative rule that I referred to. And that was Mr. Hartman's words. So to clarify that, we were saying that it can't be interpreted to conflict with the revised code. I think that's something we can all agree on. That being said, at these events, we complied with the good faith interpretation of the statute. And I agree with you that the best practice is to take that information and to either have a list, whether it be to thank your contributors or to create a record that maybe you might need to give to your treasurer. But our main argument is that it is not required by law.
Anything further, Commissioner Tavares?
No, thank you, Mr. Chairman.
Thank you, ma'am. Commissioner Knight, any questions, sir?
No, sir, Mr. Chairman, I do not have any questions at this time.
Thank you very much, Commissioner Knight. With that, I'll turn to our Executive Director, Mr. Richter.
My recommendation would still be to each respective case find probable cause and set the matter for hearing. The commission does do so. We're obligated to have the hearing set within 10 days of the date.
Mr. Richter, I apologize. Once again, it's very, very difficult to understand you.
Okay. Yeah, I've got, for whatever reason, I'm experiencing challenges, let's put it that way, in terms of what my connection is. So I'll issue a general apology, but try and respond appropriately. Anyway, my recommendation on both cases is to find that there's probable cause, set the matters for hearing, and both before the commission on May 2nd, 2022, which is within our 10-day window. As it relates to time, I would suggest either starting, potentially at 11 o'clock, 12 o'clock, or 1 o'clock, depending on what is convenient for the commission members. I can always work that out with council and commission members as time goes on. But that's my recommendation. I'll be glad to answer any other questions that the commission may have as it relates to this.
Questions of Mr. Richter by the commission members. And Mr. Richter, just so the record is clear and we all understand, it's the recommendation of the executive director that probable cause exists to refer the matters in case number 2022G-12 and 2022G-13 to the full commission for full hearing on May the 2nd, 2022, pursuant to the High Revised Code.
That is correct, Mr. Chair.
All right. Thank you very much, sir.
Mr. Chairman, I would move the recommendation of the executive director.
Thank you, Commissioner Tavares. Do we have a second?
Mr. Chairman, I did have a question for the executive director, if you don't mind.
Yes, sir. Go ahead.
Mr. Richter, I'm just curious on your perspective regarding the argument for 3517B4E, the exception that was noted by Mr. Brown's argument. I'd be interested in hearing your perspective on that.
Sure. Call up that particular statute. I've got it buried here somewhere if I can find where my cursor is. I think most interesting, certainly the section that he highlights there as it relates to the exception, as it relates to contributions of under $25. But if you read down further through that same particular section, which is long been acknowledged as a part, come on, Phil, there we go, as part of campaign finance, it's like the second last sentence, somewhere down there, a campaign committee, which is what we're talking about here, shall keep records of contributions from each person in the amount of $25 or less at one social or fundraising activity, and contributions from amounts deducted under section 3599031. That's kind of a general allowance for accumulating through corporations, etc. And so I point that out because you're obligated, you're not necessarily obligated to immediately include that information with your campaign finance report. But you are obligated to keep a listing, to use your best efforts at least, keep a listing of those contributions. And if it's ever requested by a board of elections or the Secretary of State's office, to then provide that listing that you have. And so I certainly understand the point that Mr. Brown made. There is an exception for generally listing, but there is an expectation that a campaign will maintain records of its own that may be requested. And there have been various times through the years when boards of elections, Secretary of State's office would reach back out. The commission specifically dealt with the case a number of years ago of the sheriff, not more, not Nashville County, up in northeastern county, where he over years repeatedly listed contributions of under $25 in rather substantial amounts. And when the commission addressed that particular case, it was determined that there were amounts under $25 in those listings, but there were also amounts greater than $100, or I mean $25 in there. And the commission imposed a rather substantial fine, and then the evidence came out because proper records were not necessarily maintained, and there was a violation of the statute by that particular sheriff campaign when that case was decided. So, I appreciate, some of the efforts undertaken by the Blystone campaign in their campaign finance reporting, but they are obligated to maintain either specific listings of who contributed under $25 by the statute, or if it's ever requested, or at least then declare that they have used their best effort to identify those persons who may have contributed if they aren't able to otherwise produce that information. I hope that answers your question.
It does. Thank you, Mr. Richter. I'd like to second the motion made by Ms. Tavares.
All right, very good. So we have a motion that's been duly seconded that would follow the recommendation of the executive director. And again, Phil, listen to this closely. My understanding is that you're recommending that we find probable cause to exist and to refer the matter in both cases, 2022G-12 and 2022G-13, to the full commission for a full hearing on March the 2nd, 2022, pursuant to the Ohio Revised Code. Is that correct, sir?
Mr. Chairman, I believe May 2nd, not March 2nd.
May 2nd.
Thank you very much, Mr. Hartman. You're
May
correct.
2nd,
That'd be
yes.
very difficult, wouldn't it? All right, May the 2nd, 2022. Further discussion by the commission members on the motion? Let's do a roll call vote, Mr. Richter.
I'm still having, I am hesitating only because I want to make sure that my computer is properly working again because it keeps fading in and out. I will gladly do a roll call. Mr. Knight.
Aye.
Yeah, raise your hand or say aye. Ms.
Aye.
Tavares.
Aye.
Chairman Kreitz.
Yes. All right, thank you. Motion carries by a vote of 3-0. This matter has been referred for a full hearing to the Ohio Elections Commission on May the 2nd, 2022. Mr. Richter, is there any further business to come before the commission, the panel?
There's no further matters to come before the probable cause panel, Mr. Chair.
All right, thank you very much. I'd like to commend both attorneys for a well-presented argument this morning. Thank you very much. It was most helpful to the commission in rendering its decision. With that, I'll entertain a motion that we adjourn.
So moved.
Do we have a second?
Second.
All in favor of the motion to adjourn signify by saying aye and raising your right hand.
Aye.
Opposed, same sign. Motion carries by a vote of 3-0. Have a great day, folks. Bye-bye.
Thanks, everybody.
Thank you.
Mr. Chairman?